All right, today we are diving into a really fundamental question in the legal world. Who actually gets their day in court, and who gets turned away before they even start? It often boils down to this one crucial, and sometimes pretty confusing, legal idea: standing. You've probably seen this happen, right? You see it in the news, some huge lawsuit gets filed, everyone's talking about it, and then bam! A judge just dismisses it before the real arguments are even made. The reason? It's almost always about this thing called standing. So let's break it down.
So here's our game plan. First, we're going to talk about what standing really is. I like to think of it as the courthouse gatekeeper. Then we'll get into the three-part test that courts use. After that, we'll look at where this whole idea even came from, touch on some modern debates, and finish with a really surprising twist involving criminal law.
Okay, so let's start with that gatekeeper idea. Seriously, think of standing as the bouncer at the courthouse door. Their job is to make sure that only people with a real, actual dispute get inside. You can't just sue because you're mad about something. You have to have a personal stake in what's happening.
So what is it exactly? Well, standing is the rule that says the person suing, we call them the plaintiff, has to have a direct link to the problem and prove they've actually been harmed by it. The easiest way to think about it is you've got to have skin in the game, something to actually lose.
Now, this whole concept isn't just made up out of thin air. It's rooted way back in Article 3 of the U.S. Constitution. That's the part that says federal courts can only deal with real cases and controversies. It's designed to stop courts from just giving advice on what-if scenarios. They're supposed to stick to solving actual existing problems.
So how do you prove you have standing? How do you get past that gatekeeper? Well, you have to satisfy what the Supreme Court calls the irreducible constitutional minimum. It all comes down to a three-part test. Think of them as the three keys you need to unlock the courthouse door.
And here they are, the three keys. First, you need an injury in fact. Second, you have to show causation, which just means the person you're suing is the one who caused your injury. And third, there's redressability, which is a fancy way of saying a judge's decision could actually fix your problem.
Let's focus on that first key, because it's the most important and honestly the trickiest one: injury in fact. This isn't about just feeling like something is wrong. The harm has to be concrete and particularized. That means it's a real, tangible injury that happens specifically to you, not just a general complaint that anybody could have.
Here's a perfect example. Let's say a factory is spewing pollution onto your property. You absolutely have standing to sue. But what about a passionate environmentalist who just drives by, sees the pollution, and is really upset about it? Well, they probably don't have standing because that harm isn't particularized to them personally.
Okay, so this whole doctrine is clearly a huge deal. It must be spelled out right there in the Constitution, in big, bold letters, right? Well, the real story is a little more complicated than that. And here's the kicker. The word standing is nowhere to be found in the Constitution. Not once. As the legal scholar Raoul Berger put it, it is a judicial construct, pure and simple. That means the courts themselves basically invented it over the years to figure out what cases and controversies really means in practice.
And you can actually watch this idea get built piece by piece over the 20th century. It really got going back in 1923 when a case basically said, nope, just being a taxpayer isn't enough to sue the government. Then in '62, we get the idea of a personal stake. And it all comes together in 1992 in a huge case called Lujan, which officially locked in that three-part test we still use today.
Okay, fast forward to today. Applying these rules gets really, really tricky, especially when you have massive cases with tons of plaintiffs, like in a class action lawsuit. And honestly, the courts themselves can't even agree on how to do it. Get this. There's a major split in the country right now. Some courts follow what's called the one plaintiff rule. If just one person in the lawsuit has standing, the whole case can go forward. But other courts are way stricter. They say every single person has to prove their own standing for every single claim they make. This means your ability to sue could literally depend on what part of the country you live in.
And the rules are still being written. Just recently in 2021, a big Supreme Court case, TransUnion, really shook things up. The court doubled down on that concrete harm requirement, which has made it a lot harder to sue companies for things like data privacy violations, unless you can prove you were immediately hurt in a tangible way. Critics say this just makes it easier for big corporations to get away with misusing our data.
So, up to this point, we've seen how tough these rules can be, right? How high the bar is for an ordinary person to get into court. But there's a massive exception to everything we've just talked about, a twist that kind of changes the whole story.
You have to wonder, does the government itself have to play by these same rules? When the government wants to prosecute someone for a crime, do they have to prove injury, causation, and redressability?
And the answer is a clear, resounding no. It's not even close. For a private citizen to sue somebody, they have to jump through all three of those hoops. But for the federal government to bring a criminal case against you, they only have to show one thing, that a law was broken. That's it. They don't have to prove the government itself suffered some concrete and particularized injury.
And that double standard has massive real-world consequences. Legal experts like Hessek and Benecki argue that this setup gives Congress a huge incentive. Think about it. If it's way easier for the government to enforce a criminal law than for a citizen to enforce their civil rights, what is Congress going to do? They're going to write more criminal laws. And that, they argue, contributes directly to huge problems like overcriminalization and mass incarceration.
Which leaves us with a really critical question. Is the doctrine of standing a necessary shield that keeps our courts from getting bogged down and helps maintain the separation of powers? Or has it become a kind of sword, one that makes it harder for regular people to defend their rights while giving the government a massive shortcut to control things through criminal law?
This is for entertainment and educational purposes only. This is not legal advice.